Hi, everybody. This is Mallory Flowers on behalf of Jennifer Shelton Associates, and we are coming to you live from Washington, D.C. And welcome to our Webinar Wednesday series. Our webinars are held every Wednesday in 2018 at 12 p.m. and 12:30 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the webinar tab. In the interest of time, we do not take questions, and our speaker's contact info is posted on the last slide. So if you have any questions, please contact the speaker directly. The recordings are on our website underneath the Archived Webinar tab, as well as on our YouTube channel. All right, this is just a quick blurb about us. Jennifer Shelton Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign, defense contractors and civilian, and our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. All right, so we're going to go ahead and dig into today's presentation, which is Key Concepts in Federal Subcontracting. And our speaker is Maria Panichelli. You can learn more about her background on this slide. Thank you, Maria, for joining us today. I'm going to go ahead and hand it over to you.
All right, thank you very much, Mallory. I appreciate that. Thanks to everybody out there who is joining us today. As Mallory said, my name is Maria Panichelli, and I am a partner in the government contracting group of my firm, Cohen Seglius. I focus my practice exclusively on federal government contracting, which means that I cover kind of everything that comes up during the life cycle of a contractor's experience with the federal government. So bid protests, claims, compliance counseling, small business issues, eligibility, certification, teaming, joint venturing, etc. But a big part of our practice is also dealing with the what we call downstream issues. In other words, yes, you're a federal government contractor, and if you're a prime contractor, you have issues that come up in dealing directly with the government, but there's also issues in dealing with your subcontractor, and then obviously if you're a subcontractor on federal government projects, there are issues that come up as well. So today we're going to be talking about some of the concepts that come up in that area of practice, specifically key concepts that come up with regard to federal subcontracting. Next slide, please. So the first thing that we're going to talk about is flow-down clauses. Now, flow-down clauses aren't necessarily unique to federal government contracting, meaning that they're a concept that applies in a lot of contexts, whether you have a private job or a state or local job or a federal job. A lot of times prime or general contractors are going to want to pass through certain obligations from their contract down through their subcontractors. But what makes it unique, or what makes it kind of different in the federal government world, is obviously prime contractors, when working with the federal government, have a lot less flexibility. So anytime you are a contractor, either a prime or general contractor or a subcontractor, and you're negotiating with another party about the terms of a subcontract, a lot of times you're going to be able to push on certain issues depending on the amount of leverage you have, and you're going to be able to use that leverage to affect certain changes in the draft contract. Now, one of the things that can be a little bit limiting and why it's a little bit unique in the world of federal government contracting is that the prime contractor, or the general contractor, is going to be very limited in what they are able to change in their own contract. In other words, they have certain things that they have to do, or obligations they have to fulfill, requirements they need to meet upstream with the federal government. So they don't want to leave themselves, we're going to talk about this in just a second, in a position where they're kind of stuck in the middle. So there's a lot less room for wiggle room, and sometimes a lot less room for negotiation. But hopefully when we finish today, you will have a couple ideas of areas where you can negotiate, whether you're coming at this from a prime or subcontractor point of view. So in the unique world of federal government contracting, these flow-down clauses, as they're called, can be critical. They're a feature that's present not just in federal government contracting, but like I said, can become more important in the federal government contracting context. So for those of you who have never heard the term before, let's talk about a little bit what are flow-down clauses, or sometimes called flow-through or pass-down clauses. They are, technically speaking, clauses that are included in a prime contractor's contract that are then taken and flown down or incorporated into the subcontract, often verbatim or very close to verbatim, word for word, from the prime into the subcontract. That's kind of the technical term for what a flow down clause is, a clause that's copied and pasted and maybe copied and pasted with minor tweaks from the prime contract to the subcontract. But in kind of a broader sense, it's been, or I should say, it's become known, the term flow down clause has kind of grown, and the meaning of it has kind of started to incorporate other risk shifting or protectionary clauses that prime contractors include. They might not necessarily be a verbatim restatement or a flow down, quote unquote, technically, but they are something that the federal prime contractor is taking into account, knowing what they have to do for the government, and therefore kind of shifting that risk down or flowing down some sort of conceptual framework. Next clause, or next slide, please. So why do flow downs matter? I just talked a little bit about the fact that in the federal government contracting world, the prime contractor is going to be held to certain standards, have a little bit less wiggle room when dealing with the federal government, and that is one of the main reasons that flow downs matter. But they don't just matter for prime contractors. We're going to try to take a look at this from both points of view, both prime and subcontracting viewpoints. Now, that being said, we're going to focus mostly on what prime contractors are going to be looking for and what they need to be concerned with, but not because prime contractors are more important, because if you understand the limitations and the goals that a prime has, you can, even if you're a sub, understand how this process works. So the way that we look at it is kind of understand where the prime is coming from, understand what the prime wants to do with these clauses, and then you will understand, whether you are a prime or a sub, how best to go about this process. So the reason that primes often think that flow downs matter, or why they're so critical, is that flow downs often have provisions that deal with either communication or notice requirements. If those are not flowed down, there are communication breakdowns. Those can cause notice failures, and that can defeat any potential claims or issues that you have going forward. And we're going to talk about a couple examples of that in just a few minutes. Another reason that they can be important is that no matter what, if you subcontract your work and you are a prime contractor, you're ultimately going to be held responsible for satisfactory performance of the contract. In other words, the government's not going to say, oh, I'm sorry, I know you got saddled with, an unfortunate subcontractor and the subcontractor didn't do their job. They're going to say, look, it's unfortunate that your subcontractor didn't do their job, but it was your job to supervise them, and it's your responsibility to fix whatever they messed up, and that's not on us, and we're not going to bear the consequences of it. So prime contractors are going to be held responsible for the actions of their subcontractors, and subcontractors can force a default. In other words, if the subcontractor is performing a primary or vital portion of the work that the prime is supposed to perform, and they fail to do so, and the government latches onto that as a reason that performance has been stalled, or it's not the project's not being successfully prosecuted in a timely way, that could cause a default, and obviously that's going to affect the prime just as much, if not more, than it'll affect the subcontractor. And what prime contractors are often trying to avoid, and I alluded to this just a few minutes ago, is being stuck in the middle. You don't ever want to be in any situation in life, but especially in the legal context, and in especially particular when dealing with the federal government, you don't want to be fighting a battle on both sides. In other words, if you're a prime contractor, you don't want to be litigating claims with the government upstream while simultaneously trying to fight off a subcontractor dispute downstream. Two fronts is always a difficult position. It's obviously going to be more difficult when one of the fronts is the federal government, and they have unlimited resources, and sometimes there can be delays involved in that process, which are going to make fighting for a prolonged period of time, two fronts, two sets of legal fees, etc., difficult. So usually a prime contractor's primary objective is to avoid situations where it could be stuck in the middle. Next slide, please. So let's talk about an example of, from a prime contractor's point of view, why flow downs matter. All prime contracts, all government contracts, federal government, are going to have termination for convenience clause. And that clause basically says, or does say, that the contracting officer can terminate a contract, whether in whole or in part, any time it determines that it's within the government's best interest. So this is not a termination for default. In other words, there's no fault assigned It's not blameworthy. There's no negative connotation with a contract being terminated for convenience. It doesn't mean that the prime contractor gets any bad marks on their past performance. It just means that the contract has been terminated. The government no longer needs whatever they originally thought they needed. This happens sometimes when there is work or construction going on in a conflict area, like Iraq or Afghanistan, and things change, borders shift, and interests maybe realign, and maybe something doesn't need to be built anymore. Or maybe sometimes there's a problem on site or a problem with performance, and the government realizes that in order to fix it, they would have to spend a lot more money. And given that budgetary concern, it's just not worth it for them anymore. All of these situations are situations in which it's in the government's best interest to terminate a contract. They are able to do so under this clause. Now, they have to make certain payments to the contractor for money that they've spent so far on performance, and any money that they've spent on buying materials or getting people up to speed that they can't get back. But the contract is terminated. So what happens when you have a situation that one of our clients had? Unfortunately, they did not come to us at the subcontracting stage. They did not come to us until after they had been terminated for convenience. And now that their contract was done, they wanted to turn around and terminate their subcontractors. Well, they had not flowed down the termination for convenience clause. They hadn't accounted for it in any other type of way. So now the prime contractor is stuck in a situation where the government has terminated their contract. They don't have any work that's going to be done. They don't have any money that's coming in, but they didn't have the ability to turn around and terminate their subcontractors. They had not flowed down this terminations for convenience clause, and many of the subcontractors said, well, I'm sorry that your contract has been terminated, but you don't have any right to terminate mine, and you owe me the money that you would have to pay me. I planned around that, and now you owe me the money. Now, because we have dealt with situations like this before, we were able to negotiate, and get the contractor out of that jam, but obviously it's not a situation you ever want to be in. You want to make sure, from a prime contractor point of view, that you flow down clauses like this so that you're not stuck in the middle, and so that you don't have obligations that you owe to the government, or money that's not going to be coming in from the government, and you can't account for that with your subcontractors. Next slide, please. So what then are the takeaway lessons for primes when you're thinking about, okay, how do I go about figuring out what I need to put in a subcontract? Well, it's critical to think about what your obligations are, what obligations you're going to have to the owner, to the government, and how the sub could impact your ability to fulfill those obligations or requirements. Could they delay you? If they delay you, what consequences could that have? Could they provide deficient work? If they provide deficient work, what consequences could that have? What could the government do to you if the subcontractor fails to live up to their obligations to you? You're going to want to, once you make a list of all the obligations you have and kind of analyze whether or not your subcontractor could impact your ability to fulfill those obligations or could result in other negative consequences to you, you're going to want to protect yourself by slowing down obligations, by making sure that your obligations are consistent. By that, I mean make sure that the subcontractor is responsible to you to the same extent you're responsible to the federal government. Or if you can't necessarily, quote unquote, flow down a clause verbatim or cut and paste a clause, you're going to want to try to account for potential risks in other ways. Always going to want to think about being, careful and avoid being caught in the middle, doing that battling on two fronts that I just talked about. And obviously, you're going to want to carefully craft your subcontract to accomplish these goals. A good way to do that is, to talk to a federal government contracting attorney who is familiar with all of the issues that come up, that is familiar with all of the different consequences that can flow from the disputes between primes and subs, as well as all of the issues that primes deal with upstream with the federal government. Oftentimes, if you talk to an experienced government contracting attorney, such as myself or my colleagues, we can provide a template, a template agreement rather, that you can use and tweak every time. So it's a one-time template argument or template agreement that you can then use going forward until any regulations change. Next slide, please. So let's shift for a minute. We've been talking about it from the prime contractor point of view, but like I said, it's important to think about this from both parties' point of view. So what does all this mean for subcontractors? Well, the key for subcontractors is to understand where the primes are coming from, which we just talked about, and furthermore, to know what their obligations are and know what procedures they are bound by. In order to do so, subcontractors need to understand and they need to be very clear on which clauses have been flowed down and what obligations those clauses impose, and also, of course, what other risks have been shifted. And it sounds like common sense. In other words, I'm basically saying contractors need to be aware, subcontractors need to be aware of what their contract says they're responsible for. Pretty common sense argument, right? Well, you'll see why sometimes it cannot be. Next slide, please. This is the most common mistake we see subcontractors make. And it's unfortunate when subcontractors make a mistake like this and then come to us afterwards. Because obviously this is something that we recognize, and if we were involved in the drafting process, we could make sure that a clause like this is not present in a subcontract that our client signs. But what we see a lot of times is one of these general catch-all provisions that says something along the lines of, the subcontractor shall assume towards the contractor all obligations and responsibilities which the contractor assumes towards the owner. And notice that it also says all responsibilities under the prime contract. And then similarly, the contractor has the benefit of all rights and remedies and redress against the subcontractor that the owner has against the contractor under the prime contract. Next slide, please. So what you'll notice is that in that general clause that we just went through, there are references to a prime contract, and there are further what we call mirroring obligations. In other words, the subcontractor who signs an agreement with that clause in it just agreed to be bound to the prime to the same extent the prime is bound to the owner. But what happens a lot of times is subcontractors sign that agreement without seeing the prime contract, without ever looking at those documents, without really understanding what extent the owner is requiring things of the prime contractor, or what extent the prime contractor is bound to the owner. So the subcontractor really doesn't know what they just agreed to. Here's an example of that. We represented a subcontractor who was working on a construction project in a building out in Colorado. The contract was supposed to be mostly for renovation, and a small piece of it was supposed to involve asbestos abatement. And our contractor, our client, the subcontractor, was the asbestos abatement subcontractor. Their portion was supposed to be pretty small. But when they got there, they determined that the asbestos was in much larger quantities and was in additional rooms and was in many different forms. So in other words, instead of being a small quantity of asbestos on only a couple rooms on the first floor and only in the form of insulation, it was all over every room and every floor, and it was not just insulation, but pookie pipe and duct sealant, etc. Now, that is a differing site condition. The differing site conditions clause, which is here up on the screen, says that if you encounter subsurface or latent physical conditions at a project site which differ materially from those indicated in the contract, in other words, the contract said asbestos was going to be very minimal in a couple rooms and in limited forms, but you got there and what was actually there differed materially. It was in a lot of rooms, in a lot of forms, in much greater quantities, etc. Then you can get an equitable adjustment to the contract. In other words, additional money and additional time to account for the differing site conditions that you have encountered. Next slide, please. But the differing site condition clause goes on to state that no request for an equitable adjustment shall be allowed unless the contractor has given written notice required. So the prime contractor understood these requirements. They were a very sophisticated, very experienced prime contractor, had done business with the federal government, had a documentation system in place where, as soon as they encountered something that could be deemed a differing site condition, they usually would provide notice to the government to fulfill this obligation and set themselves up or preserve their rights to file a claim later. But they had in their subcontract one of those general catch-all flow-down provisions that we had up on the screen a couple slides ago. Well, what that meant was that the subcontractor didn't really fully understand what they had agreed to. They agreed to be bound to the prime to the extent the prime was bound to the owner, They didn't know that meant that they had all sorts of notice requirements. So they did not provide the requisite notice, and it created problems not only for themselves, but for the prime contractor. So whether you are a sub or whether you're a prime, those catch-all provisions are not advisable. Next slide, please. So what are the takeaway lessons from a subcontractor's point of view? First and foremost, make sure you understand the obligations and procedures you're bound by. Never accept a vague slowdown clause. To the extent that you have a clause or a proposed clause that is referencing a prime contract, you're going to want to make sure you see that prime contract, get a copy, explicitly discuss what is being incorporated. At the same time, advocate that the prime's obligations to you mirror the government's obligations to the prime. And again, you're going to want to carefully craft your subcontract, hopefully with the advice of a legal professional that's experienced in federal government contracting, so that you can address these concerns, or at the very least, so that you can understand what your responsibilities are under your subcontract. Next slide, please. So how do you determine what should be flowed down? This is often a question that depends on the nature of the contract and how risk-averse you are. The FAR itself will state whether a clause must be flowed down. Sometimes right in the language of the FAR, if you look up the clause, it will say this clause must be flowed down. In that case, it's a mandatory flow down clause. In other words, if you are a prime contractor, you must flow that down. Now, be careful. Some people get confused between mandatory and automatic. If the FAR says you have to flow this down, it doesn't mean that it's quote unquote automatically flowed down. It doesn't mean, oh, no matter what, you don't have to do anything. This is considered part of your subcontract. Quite the contrary, it means that you have an affirmative obligation to put that clause in your subcontract. Now, in addition to those mandatory clauses, there are some concepts or some clauses that are suggested, or just some ideas or risk-shifting provisions that should be considered. Now, we talked about the terminations for convenience example. That's not a mandatory clause, but that's obviously something that a prime contractor should keep in mind and always want to consider. Next slide, please. Other things that you're going to want to account for are on the screen right now, and this is by no means an exclusive list, but it's some of the most important changes, differing site conditions, notice with regard to changes and differing site conditions, dispute resolution, claims, certification of claims, payment timing, in other words, pay if paid, pay when paid clauses, terminations, especially for convenience, but also for defaults, and suspensions. Next slide, please. All right, so one of the main areas that you need to keep in mind when you're talking about subcontracting is subcontractor pass-through claims. So we're going to talk about those very briefly so that you are aware and kind of have a primer on those, because that's going to inform how you deal with the dispute resolution ideas in your subcontract. Next slide, please. So, as a general rule, there's something called sovereign immunity. For those of you who are not aware what sovereign immunity is, it's a general rule that says that lawsuits against the federal government are prohibited. In other words, you can't sue Uncle Sam. Now, there are exceptions to that. And one of the exceptions to that arises under something called the Tucker Act. It's a law that's in the United States statutes. And it says that while you can't generally sue the federal government, if you have a contract to which the government was a party, in other words, if you're a prime contractor and you've entered into a contract with the federal government, then that's an exception and you can enter into a lawsuit against the federal government. But notice that the exception only applies if you yourself have a contract with the government. So in order to take advantage of this exception, there has to be a contract. There has to be what's called privity of contract. Prime contractors will have that because they have a direct contract with the federal government. Subcontractors will not. Therefore, subcontractors do not fall within this Tucker Act exception, and they fall within the general rule, meaning that they cannot sue the federal government. Next slide, please. So, what happens if a subcontractor has something wrong, has something go wrong on a project, and it's the responsibility of the owner? Well, they need to have their claims, quote unquote, sponsored by their prime contractor. This is called a pass-through claim. The prime is passing the subcontractor's claim through upstream to the owner. These claims are always going to be ruled by what's called the Contract Disputes Act. You'll hear it sometimes referred to as the CDA. the prime has to affirmatively agree to sponsor the claim. And I will tell you, sometimes they refuse, and we're going to talk about that in just a second. This can be a huge source of prime-sub conflict, and it's something that you're really going to want to think your way through and address with your potential prime or subcontractor while you are drafting the subcontract agreement. Next slide, please. There's always going to be differences of opinion on this topic. The prime's concern is usually going to be, okay, I don't have a problem passing through a claim, but what if there's a problem with that claim? What if my subcontractor was fraudulent or not that careful or not that diligent in putting together a claim? I'm still the one that has to certify it while I pass it up. What happens to me if I certify a claim that my subcontractor didn't do a good job on or was fraudulent in? The sub's concern is going to be, look, I understand that you want to have some sort of recourse if I do something wrong in terms of putting together a claim, but what's my recourse if I have something that went wrong on the job? I can't sue the federal government myself, and you're refusing to pass through a claim. The key is to address the prime's concern. You're going to want to put conditions on passing through claims. In other words, okay, I'm the prime contractor. If you really want me to pass through a claim, here's the hoops you need to jump through. And to assuage the sub's concerns, you're going to want to make sure that the disputes clause clearly indicates a way to have a case against the prime, and that they can kind of the sub can go after the prime for breach of contract if there's a problem with the claim. And I've included this case here for those of you who want to look it up. It's a very good example of what happens when a prime refuses to pass through a claim. In that situation, unfortunately, the subcontractor made a mistake and still tried to go after the federal government. And the Board of Contract Appeals said, no, I'm sorry, your recourse is not against the federal government. You don't have any privity. You have to go after the prime. So for those of you who are interested, check out that case. It's a good lesson to be learned. Next slide, please. So how should you deal with these concepts in your subcontract? Again, you're going to have to talk your way through and make sure that everybody is on the same page between the prime and the sub in order to make sure these ideas are dealt with. Subcontracts should address how pass-through claims are going to be dealt with. That's going to mean that there should be a disputes clause, and the disputes clause should draw a distinction between how to handle a subcontractor's claim between a sub and a prime and how to handle a dispute against an owner. In other words, if you're a subcontractor, something went wrong on the project and you think the owner is responsible, what are the conditions on the prime passing that through to the owner? Okay, well, what if it's not that you think the owner did something wrong? What if you think the prime contractor themselves did something wrong? How do you go after them with regards to a breach of contract claim? The subcontract should clearly delineate each party's responsibility with regard to pass-through claims in particular. In other words, the prime has to agree to some level to sponsor the claim, and the subcontractor has to agree to certain conditions and also to cooperate fully in putting that claim together so that the prime's not on the hook with a fraudulent or problematic claim. And those are just, again, general concepts. That's something that you're going to want to talk about in much more specific detail and include a legal professional that's dealt with these issues while drafting your subcontract. Next slide, please. So I've kind of alluded to this on the past few slides, but now we're going to talk very briefly, just for a minute, about subcontractor claims against primes. Next slide, please. As I said, when you're talking about disputes, there should be a clear demarcation in a subcontract between disputes that are, subcontractor versus owner being passed through from the prime, by the prime, and subcontractor disputes that are sub versus prime. Many disputes that are sub versus prime in the federal contract world revolve around a prime's refusal to pass through claims, or sometimes, even if they are passing them through, subcontractors get impatient. That CDA process can be kind of, time-consuming. If a prime refuses to honor a subcontract, the subcontractor can bring a suit against the prime. Usually that comes up in the appropriate U.S. district court. So then you're going to be dealing with issues there. This is, again, something that you want to talk about and work through as part of your subcontract arrangement. You're going to want to think about all different permutations and, potential fact patterns. In other words, if this happens and this happens and this happens, and I, the prime contractor, pass through your claim, but the government is delaying and delaying and delaying and not getting back to us, Am I going to give the sub the ability to try to sue me in the meantime? Or am I going to include a clause that says that they're not allowed to do that? They have to await what happens with the federal government? Or am I going to put a mandatory arbitration clause in there to make sure that it kind of slows the subcontractor down and they can't take me to district court? Again, always think from a prime contractor's point of view, you want to avoid fighting a battle on both fronts. From a subcontractor's point of view, you're going to want to make sure that you're not left without any recourse if the prime doesn't pass through your contract. How can you go after, pass through your claim? You're going to want to leave yourself some remedy to go after the prime themselves. This is something that is, a big source of conflict and often the most important part of drafting a subcontract. And I think next slide, that brings us to the end of our key concepts in federal government subcontracting. I know it's a lot of information. That was just a primer on kind of the concepts you need to keep in mind. If you have questions, you can feel free to reach out to me. My contact information is on the slide there. And with that, I will turn it back over to Mallory.
Thank you, Maria. That was a lot of great information, and thank you for sharing your time with us today, and thank you for everybody who joined us. Like she said, if you have any questions, please contact her directly with the information you see on your screen. Next week at noon, we are covering strategies for subcontracting, and at 12:30, we are covering understanding rate multipliers and wrap rates. Thank you, everybody. Have a good day.